how has COVID-19 changed how to prepare for a court hearing from a legal perspective? If there is anything changed, Amy?
Well, it has. Now, depending on the application that you're filing. So if you are in a situation where you are directly affected by COVID-19, that is, if you cannot spend time with your children because you're interstate, if you cannot spend time with your children because the supervised contact centre is closed, or if there are situations of family violence, then the urgent COVID-19 list that has just rolled out is fast-tracking parenting cases. So in terms of the preparation for the hearing, the court is adopting a process where if you send in your application, you will be allocated a hearing date, provided you meet the criteria for urgency. You'll be allocated a hearing date within 3 days, and that hearing will be conducted virtually. So in family law terms, that's an extremely fast turnaround. The traditional time.
Wow.
Yeah. 3 days. 3 days is quite amazing for family law matters. Yeah. The usual time frame is between 6 to 8 weeks for your first court date. So there's that issue in getting it in urgently, because we're in a very unusual situation, as we know. If your case is not COVID-19 directly related to that, then the way that the court is conducting matters by attending virtually or by the telephone means that we as solicitors and parties who are involved in court proceedings are no longer having the face-to-face negotiations that we would normally have on the doorstep of a hearing when you're at court and you're waiting to be called. But what it does now, though, is we are now utilising the days before the hearings and the morning before the hearing starts to open those negotiations. And it can mean that by the time your matter is ready to proceed and you're before a judge, and I'm facing this regularly in my appearances, you've already narrowed many of the issues because you are negotiating well in advance with the other party, meaning a lot of the time what is left to have the court decide is one or two issues instead of the 10 that you would normally have when you file the application. So it seems to be a far more efficient use of time, both court, but also importantly, I find for my clients and me, so we can get things resolved far quicker, I found, than we would traditionally.